need to understand how people outside the field in which we operate see us. That is not the mission of this committee. As the SGS versus Pakistan annulment, as the decision there, the disqualification decision reads, what you look at is whether the facts are of such a nature as to indicate a manifest lack of the qualities, as we've been discussing, and the critical inference must be reasonable in view of the facts from which it springs and should accord with the common experience of the pertinent community of arbitrators and lawyers. That's who we're concerned about here. And that's why in opening, I also referenced the widespread practice of so-called double hatting in arbitration. And you see that again in the draft code. It's not there's been a lot of back and forth, but it's currently widespread practice. It's not currently proposed to be prohibited. That's what we're looking at. We're not looking at people who are just in the general public who may not know anything about the field and taking a survey and saying, hypothetically, what do you think about this? That's not the inquiry at all. And I just wanted to reiterate again that I think it is clear as day that the ICSID administrative chairman did reject the ISER committee's reasoning and result. And this morning we heard that that was not the case. In light of the time, I won't reread these paragraphs, but you can see very clearly that the ICSID administrative chairman is copying over the argument that respondents make based on ISER. They're saying then that is not correct, and you cannot assume that there is a relationship or a special relationship between an expert and counsel and that they're unable to maintain professional distance. What you need are objective facts to the contrary. And indeed, Professor Boo asked this morning also, is Misen entitled to more weight because it was issued by the chairman of the ICSID Administrative Council? And absolutely it is. And that is for it because the chairman of the Administrative Council, he's going to be deciding these types of issues on an ongoing basis. Of course, as you know, when the arbitrators are undecided, he is the decision maker. And also, if more than one arbitrator on the tribunal is challenged, he also is the decision maker, but he's the president of the World Bank, and his views reflect the views of ICSID on its own convention and its own arbitration rules. So of course that has to carry more weight than the views of unchallenged members of other tribunals. It of course does. This is ICSID itself proclaiming how its convention and rules are interpreted and what the responsibilities and duties are underneath them. And in that regard, I would again emphasize the utter lack of evidence from Guatemala that the relationship at issue here was anything other than a working professional relationship. And as Professor Jones has said, I mean, experts are independent. They owe that duty to the tribunal. I mentioned in opening, in fact, they give an oath to that effect, and you can see that in Rule 35 of the ICSID rules, where each expert has to make the following oath. They have to declare upon their honor and conscience that their statement will be in accordance with their sincere belief. And we have other authorities on the record where it's recognized that there's an expectation that experts owe a duty to the tribunal, that they should be independent, and they're expected to provide the tribunal with some objective truth and not just the appointer's version of the truth. And in fact, I noted the not only likelihood, but the almost, the word escapes me, but that necessarily almost when you have a practitioner who is as prolific as Dr. Alexandrov, and you have both as counsel and arbitrator, and you have Mr. Kaczmarek, who is the foremost, literally ranked as the most used quantum expert in the world on investor state arbitrations. They are bound to have come into contact with one another. But if you look at that same survey, which is at CEA 40 at page 92, not only is Mr. Kazmarek ranked as the #1 quantum expert, he's also been appointed by claimants and respondent states in equal measure. So that survey showed that he had 19 claimant appointments and 20 respondent appointments. That shows that as experts are expected to be, to owe a duty to the tribunal, both claimants and respondent states have found that they respect him and they hire him, they engage him, and they believe that he is an independent expert who knows the field and can act impartially. Now, Professor Jones, you talked about your article, and this morning, Mr. Tortorola responded on the article that you drafted. And I'll quote, he said, "And you, Professor Jones, have cited a study by Queen Mary, University of London, and White and Case that says that 90% of all those surveyed have doubts about the impartiality of experts." And look at the date of the survey. It's 2018, at the same time when all this was happening. Now, if you look at page 11 of that article, it states, and I'll just quote it, "The 2012 International Arbitration Survey from White and Case and the Queen Mary University of Law found that 90% of expert witnesses were appointed by parties rather than by the tribunal. The survey did note, however, that respondents' preferences were not so polarizing. 43% of respondents found party-appointed expert witnesses to be more effective, as opposed to 31% favoring tribunal-appointed experts. The article does not state that 90% of all those surveyed have doubts about the impartiality of experts. It merely stated that 90% of expert witnesses were appointed by the parties. And then it goes on to say that 43% found that party-appointed experts are more effective, where 31% found that tribunal-appointed experts were more effective. The article then goes on to cite a number of issues with both party-appointed experts and tribunal-appointed experts, and the pros and cons of each. Now, I just note again, today, Guatemala acknowledged that while it has been emphasizing that the pendency of the Littercon case during the proceeding, that the Lone Star case was also ongoing during that same time, and that Dr. Alexandrov and Mr. Kazmarek were on opposite sides of the case in that proceeding. They merely said, well, because of the amounts at issue, it doesn't make it more important. Well, there was more at stake, but the fact remains that this shows that the experts and, Mr. Kazmarek and Dr. Alexandrov were not, as they said, tied to the hip, an inseparable duo, always working on the same side, that they were acting as that it was nothing more than a working professional relationship. And I put on this slide so you could also see here the Spence versus Costa Rica case, which they mentioned this morning after having not really discussed it much in their reply submission, after we noted that there was nothing ongoing in that case that would have involved Mr. Kazmarek during the pendency of our proceeding. But we put those dates there for you. And finally, I just note that, and we talked about this.
Ms. Malika, just pause there for a moment.
Yes. Thank you.
Just wondering, when you suggested that the Lone Star case and the Littercon case happened at the same time, does it mean that one cancels out the other and that there's no need for disclosure of the Littercon case?
No, I don't think it has any impact on the disclosure issue. I just think that what it shows is that those assertions by Guatemala are incorrect, that this was not some type of special and unsavory relationship or something that is was wrong and that went beyond an ordinary professional relationship, which the ICSID administrative chairman said was acceptable. And so, because if you are working both, their presumption is that because they were working for the same client on the same side of the case in Lidercon, that when Dr. Alexandrov was assessing Mr. Kazmarek's testimony, he was biased in favor of him because he's thinking he's the expert for Peru in my case. So we're very closely tied together and I will always accept what he's saying. But simultaneously, he's fighting a huge case where he's bringing a $4.5 billion case and Mr. Kazmarek is saying he's wrong. So they're on opposite sides. So they have that as well. And I think that shows that their relationship was just an ordinary professional relationship and nothing more. And there's no reason to think, and certainly no reason to presume that he would be biased. He may well have, he has all of this in his mind. He's not going to be biased in favor of him. This is just an expert who testifies every case on its own merits, and he will assess it. Sometimes he agrees with Mr. Kazmarek, sometimes he doesn't.
Okay, thank you.
And I know we discussed this somewhat before, but just to wrap up, Guatemala hasn't shown, and they can't show, that the alleged new facts would have had a decisive effect on the award. This is, of course, one of the reasons that we have highlighted as to why the ICSID Convention is framed in the manner in which it is, because you should never be put in the place of speculating as to whether or not there would have been a decisive effect. The only people that are able to tell us that are the tribunal itself, which is why revision is the appropriate remedy. But on the actual facts themselves, you will see that in ISER, the committee basically just assumes that there's going to be a material decisive outcome. They basically say once they find and they review de novo whether the disqualification attributes are there, that automatically has deprived the party of a fair proceeding, and that would have had a material decisive effect, regardless of whether there was unanimity. But look what other tribunals and scholars have said. In Vivendi 2, the committee stated that it would be unjust to deny the claimants the benefit of the award now that there is no demonstrable difference in outcome. Guatemala has failed to show any demonstrable difference in outcome. And then they go on to say claimants appointed Professor Kaufman-Kohler and may have felt that it was their duty to defend her in the annulment proceedings, but they bear no responsibility for her or her action or inaction. And as Doak Bishop and Sylvia Marchilli in their article comment, that if the award was decided unanimously or by a majority and the challenged arbitrator issued a dissenting opinion, which, as we've just been through, was the case here, annulment may not be justified. So again, that is evidence that there was no undue swaying of the other arbitrators, let us say, by the so-called impugned arbitrator. So with that, I will end, and we can either take a break or I can turn the floor over to Mr. Polacek. Oh, yeah. And if we can also get our time, I think that would be helpful.
Yeah. Check on time, please. I look at the boss. Would you like a break?
That means there's an hour and a half left. There's
How-
an hour gone.
Do you expect?
There were a lot of interruptions.
Do you expect to be using the full allotted time? Because I don't see that there's many slides left, but I don't know if that.
We went silent.
I think it depends on your questions. Honestly, I don't, as to,
Let's break for 10 minutes
Okay.
then. And And let's say from there, 10 minutes until 25 past.